Thank you all, and welcome. I'll share my slides in just a second, but I will say that in many of my presentations that I've done for the BBB, many of the organizations have been very small. So I did gear my presentation toward employers that have fewer than 15 employees. However, I will say that we will talk about some of the federal laws and the laws that impact larger employees, but many of the things that we talk about will be geared toward employers with 15 or less. So I do want to say that up front, because in many of our presentations, we've had smaller employers, but I see that the larger ones are interested in HR too, which is great. So I'm going to go ahead and share my slide. Let me put it in presentation mode. Here we go. All right, so let me know if you see the slide. Thumbs up, anybody?
Yes, ma'am, it's perfect.
All right, perfect. So this is employment laws, what smaller employers need to know. I do have to say, as is always the case, that I'm not an attorney, and this is not legal advice. So even though we're talking about employment laws, this is not legal advice. It's really just helping you understand the regulations and your obligations under the regulations. So as I tell you that I'm not an attorney, I'm going to tell you why people get sued, right? So some of the top reasons that employers get sued are interview questions. So sometimes some of their interview questions might be illegal or could potentially cause them to get information that they shouldn't otherwise have. Performance evaluations. And what I mean by performance evaluations, I think that many times organizations have performance evaluations and they are perfunctory, right? We just say meets, right? But the reality is that the person has things that they need to work on. So we give them their performance review in January, and then in March, we're ready to terminate them for all of these things that they've done. But the performance review says they were great, right? So sometimes that is something that comes back to bite employers. Making rash disciplinary decisions. Sometimes we have a manager, they just get mad about a situation and terminate someone without having thought about all of the other information and, quite honestly, the unintended consequences. Errors in termination, again, not thinking about all the things that we need to consider when we're terminating someone. In Maryland, we have fewer of those issues. In California, people have to get paid the same day. In DC, they have to get paid within 48 hours of termination. So there are just some things that you have to know around even the termination process. Uninformed medical requests. So asking people medical information that sometimes we don't need that level of. So we don't necessarily need to know what someone's diagnosis is. We just need to know whether or not they can perform the job, right? So sometimes that can be a reason. Uninformed supervisors is another reason. And uninformed supervisors, more importantly, means we didn't provide them with enough information to know that there was a red flag to either come to HR or to reach out and say, hey, I think we need to make some different decisions and think about this differently. So providing that training for our managers who are really on the front line of working with the employees. Incorrect exempt and non-exempt decisions. So exempt and non-exempt meaning who gets paid overtime and who doesn't get paid overtime. I cannot tell you how many clients I go into where the classifications are incorrect, right? So we're going to talk a little bit today about that. Docking employees' pay illegally. I also cannot tell you how many times, because we process payroll for a lot of our clients, and we'll have employers say, oh no, don't pay this person for this or take this out of their check. And we're like, whoa, that's not something that we can, deduct for. And we'll talk about that a little bit as well. Failing to respond to complaints. If someone makes a complaint, no matter how chronic of a complainer that person might be, you definitely should look into everything, because it might be that one time that you don't look into it, that it could be a real issue that could be an impact to you as an employer. And then finally, improper classification. Similarly to the exempt and non-exempt, W-2 versus 1099, we see it all the time going into organizations. They have people classified as 1099s when they really should be W-2s. So we'll talk about that as well. So I'm going to give you some context going into this conversation because there are a variety of laws that employers have to comply with. There's federal law, state law, local law, and Maryland is becoming increasingly having more counties making regulations that are different from the state. And then Maryland as a state is making laws that are different than the federal. So to help you understand the hierarchy of the laws, we're going to talk about the fact that federal laws are the laws that are set for the entire country, and then state laws are for employers in a particular state. In the event that there is a law that conflicts, so a state law or a local law that conflicts with the federal law, it is the law that is most beneficial to the employee that will be the law that you have to comply with. So easy example, minimum wage. Minimum wage in Maryland is significantly higher than the federal minimum wage. Therefore, Maryland employers must pay employees that work in Maryland the Maryland minimum wage, not the federal. Most recently, we've had Montgomery County and Howard County implement minimum wage regulations that are even more beneficial to the employee than the state of Maryland. Therefore, if you're in Howard County, you must comply with the Howard County regulation, which is more beneficial to the employee. So that's how you determine which law you have to comply with, all right? And as I go along, please ask questions. When we talk about any of the laws, in most instances, we're going to be talking in terms of employment decisions. So we're going to say you can't make an employment decision based on this, or employment decisions must include this. We're going to kind of define what an employment decision is, because sometimes it's not very clear what is covered under employment decisions. So it's not just hiring and firing, but it also includes compensation, how you classify people, whether or not you transfer someone, promote them, bring them back from layoff, how you advertise your jobs. And I can tell you a story about job advertisements. I used to work for a very, very large company, multi-billion-dollar company. One day I went to the corporate mailbox. Well, not corporate mailbox, but I went to our little mailbox. You know how you have cubbies and, the little mailboxes, pulled out an envelope that was about this thick. And it was from the Department of Justice, and it was literally printouts of job postings that we had posted across the country, and with a letter that said, you are in violation because your jobs said that you wanted people who were junior, energetic, young, and ultimately it was determined by them that we were in violation of the Age Discrimination and Employment Act. So we had to put lots of processes in place to correct that. So even your job advertisements are considered an employment decision. Recruitment, testing, use of facilities, fringe benefits, training, pay, retirement plans, all of those things are considered an employment decision. So again, as we talk about these employment laws, I want you to keep this in mind, that it's not just the hiring and the firing. It's any of these things here that you see that are considered an employment decision as it relates to these regulations. So discrimination, I think that that's probably the type of thing that we think about the most. We think about employment laws. So who is protected from discrimination? Ideally, everyone, right? I don't think that any employer goes into a situation wanting to discriminate, or at least we hope that they don't. But from it being actionable for someone to say, I have been discriminated on the basis of, here are the categories. Sex. Sex now includes pregnancy, sexual orientation, or gender identity, and that's at the federal level as well. The state of Maryland does recognize those as well. National origin, religion, color, race. Sometimes there are questions about what's the difference between color and race. Color is the pigment of your skin. Race is how you identify yourself as it relates to being Black or white or Asian. So that would be the distinction between the two. Disability, age, genetic information, and in Maryland, marital status is protected as well. I will say that age at the federal level is protected at 40 or older. However, in the state of Maryland, age is protected, period, okay? So it doesn't necessarily have to be over the age of 40. I know I'm giving a lot of information, so please ask questions.
Yep. I was just about to say I missed, and now I've got my chat open so I don't miss again. One of your earlier slides was with regards to state-specific laws and remote work. So would that be the state the employee lives in or where the business is located?
That is an excellent question. And it is always where the work is performed. So if just because you're a Maryland employer, if you have employees working remotely in another state and they are performing that work out of their home, that becomes their work site. And then the laws of that state become the laws that govern that employee. So if you have someone in California, which is the most employee-friendly state in the whole world, then you are bound to California employment laws in any of the other states. And that would include minimum wage, overtime. And there are a lot of states that have overtime laws that are very different. And we'll talk about that when we get to that slide, but very, very different than Maryland or the federal. So that's a great question. It's where the work is performed. Yep.
So just for clarity, I have 2 employees in Delaware, 1 in Florida. So as I'm doing that, for those 3 employees, I need to understand all the employment laws related to them as employees and what I am required to do for them in those states.
Yes.
Okay. And my question will be later on as you get to it. Is there the resource, how I find that information? So I'm sure you're going to get to that later, so I'll be quiet now.
No, you're good. And I will also say that as it relates to any of the employment laws, there's always an employee number threshold, right? So, you know, an employer that has 15 or more employees or an employer that has 20 or more employees, right? Even if you only have 1 employee in that state, the employer size is based on the total employer size in total. So if you have 35 employees in Maryland and 1 in Delaware, you are a 36 employee company and have to abide by any regulations as it relates to employee size in total. So it's not just number of employees in that state. And I think that's important too, because I think sometimes employers think, well, I only have 1 employee there. It says you have to have 15 or more. No, it's employer size. If you are an employer that employs a certain number of people in total, not just in that state. All right, so many of you on this call are larger employers. We're not going to go into a lot of detail on these regulations, but the regulations for larger employers, meaning 15 or more employees in this instance, would be Title VII of the Civil Rights Act, which is basically the non-discrimination laws, and the law that governs harassment, sexual harassment, and other types of harassment. 15 or more employees, it is governed by the Equal Employment Opportunity Commission, the EEOC. Americans with Disabilities Act, 15 or more employees. This is the regulation that requires that you allow an individual to the opportunity to work as long as they're able to perform the essential functions of their job with or without a reasonable accommodation. And so that is the regulation that requires that. Pregnancy Discrimination Act. This is the federal act. Maryland also has a pregnancy act for 15 or more employees as well. And it basically means that you cannot change someone's job or require them to do a different job because they are pregnant. So they can request it themselves, and then it would become more of an accommodation issue, but you cannot require it as an employee, as an employer. The Genetic Information Non-Information Act, GINA, basically means you can't request genetic information and use it to make employment decisions, whether that's family history or otherwise. We have a new law in Maryland that will go into effect. Well, the regulations will be out next year. People will be able to take leave under it in 2025. But the Maryland Paid Family Leave Act, which is essentially the state equivalent of FMLA, but it has some additional nuances that goes into effect fully in 2025. Basically, this is going to be a contribution from both employers and employees. They will contribute to a fund similar to unemployment, and then employees will be able to request leave from the commission. So it's not something that employers have to administer. Employers just have to allow the leave. And more information will be coming out. It just passed maybe about 4 weeks ago, and they don't have the final regulations. They actually will not have all of the final regulations until next summer. The Age Discrimination in Employment Act basically says that you can't discriminate against people over the age of 40. Some requirements, if you do severance agreements for ADEA, and that's for employers of 20 or more employees, COBRA, 20 or more employees. So that's the continuation of benefits. So if someone leaves your organization, you have to offer them benefits after they leave. There was a COBRA extension, and I did not check before this presentation to see if it was still in place, but it was requiring employers to offer paid COBRA to individuals who left the organization, whether it was COVID related or not. I believe it's expired, but I don't know for sure. So I'll follow up after this presentation with that information. And then finally, FMLA, which is paid, it's unpaid medical leave, and that applies to employers with 50 or more employees. So I'm not going to get into all the details of that, but those are the laws for employers. And I want to be clear, this is not an all-inclusive list of laws. There is an unlimited number of regulations locally, federally, and statewide that employers have to comply with. These are just the ones that are the ones that are most high profile as it relates to compliance. All right. Any questions? Everyone's really quiet, which makes me nervous.
Yeah, there's no questions in the chat box, but good pause time. Does anyone have any questions? Just quickly unmute and jump right in. All right, I guess keep going, Ms. Kimberly.
Okay, so the laws and the regulations that we're going to cover today are the wage and hour laws, the Maryland Healthy Working Families Act, paid family leave. Well, actually, we're not going to cover that. I didn't update this slide, but we're not going to cover that in this presentation in depth. The Fair Labor Standards Act, the OSH Act, the Occupational Safety and Health Act, and then Immigration Control and Reform Act. We're going to cover those today. So for wage and hour, there are several things that I think are important to know. There is a minimum wage that you have to pay employees. Employers know that. It's important to know, though, that you need to know what that is where you are. So if you have remote employees, it's going to be different depending on the state that your employees are in. And then even again, in different counties. So Montgomery County and Howard County at this point have different minimum wage laws than the states. So making sure that you understand what those are. The other thing that's important to note is that, you do have to pay overtime for any hours worked over 40 in a work week. And a work week, as defined by both the Fair Labor Standards Act and Maryland, is 7 consecutive work days. So you define what your work week is, but it's 7 consecutive calendar days, 7 consecutive calendar days. You'd get to define what that is, but overtime is not based on a pay period. So sometimes people look at, well, we get paid every 2 weeks, and as long as you work, 80 hours in that week, you're fine and you're not overtime. Well, if they work 45 hours one week and 35 hours another week, they actually are entitled to overtime, even though that total is still 80. So being clear about what your work week is and how you're calculating it for overtime purposes. Other states do have different regulations for how overtime is calculated. So make sure that if you do have remote employees and people in other states, that you're clear about how overtime is calculated. DC, Colorado, California have different ways that they calculate overtime. Deductions from pay. This one is an interesting one. I see so many employers that want to deduct a variety of things from people's paychecks. The first thing that I will say is that if you want to deduct something from someone's paycheck, you should assign a value to whatever this item is at the time that you give it to the employee, or you need to have a policy around what is going to be deducted from their paycheck. So whether it's benefits, whether it's key cards, uniforms, computers, cell phones, whatever it might be, assign a value to it, and also get a document signed from the employee that you issued that item to them, that they will, that the value of it is X, and that if they leave the organization or if it needs to be replaced, it will be deducted from their check. You definitely have to have that in writing. You can't arbitrarily assign a value to something after the fact. The other thing to note is that even if you deduct something from someone's check, they must always be left with at least minimum wage for the hours worked. So for example, and I don't do math very well, so I'm gonna have to give you a very basic example. So if someone makes, let's say, $25 an hour, and they work 80 hours, okay? They have some type of equipment or something that they have broken, lost, whatever, and you want to take it out of their check, and the value of it was $2,000. Well, you won't be able to take $2,000 out of their check because they need to be left with whatever is the equivalent of minimum wage for the number of hours that they work. So for ease, let's say they work, at the rate of minimum wage where they are is $12.10, which is Maryland's minimum wage at this time. They need to be left with at least $12.10 times 80 in their paycheck. You can take the rest out. So it's important to understand you can't just zero out someone's check because they owe you money. That is not permissible. You have to leave them with at least minimum wage, and the same for their final paycheck. I know that sometimes people say, well, then I'm going to lose money. That is the risk that you take. There's risk involved with being an employer, and that's the risk that you take when you give someone equipment or you give them something. You do have the option to pursue them civilly. You can absolutely take someone to small claims court for not returning something. You can absolutely pursue them in other ways, but you cannot not give them a final paycheck, and you cannot deduct below minimum wage for the hours that they worked. Pay frequency. In Maryland, hourly employees must be paid at least every 2 weeks, and salary employees need to be paid at least once a month. And I have seen some organizations that pay their hourly employees once a month. In Maryland, you have to pay hourly employees at least twice a month. It can be every 2 weeks, or it can be bi-monthly, but it has to be at least every 2 weeks. And then finally, meal and rest breaks. Maryland doesn't really have a lot of requirements for meal and rest breaks in general, but there are some for certain industries. So entertainment, retail, hospitality industries do have some meal and rest break requirements. And I would definitely recommend, if you're in those industries, to confirm what your obligations are. But in general, there's no requirement for meal and rest breaks or for those meal and rest breaks to be paid. Any questions on anything that I covered on this slide? Just say something, just say hi, because no one's saying anything. No?
Hi, this is very informative.
Thank you. Thank you.
And somebody said, oh, I'm busy taking notes. So,
Okay.
yeah.
All right, I'll take that too. So the Maryland Healthy Working Families Act, this is the paid sick leave regulation that passed, I would say in 2018 it passed. So it requires employers to provide paid sick leave to their employees if they have 15 or more employees. If they have fewer than 15 employees, they have to provide the leave, but it doesn't have to be paid. But every employer in Maryland must comply with the regulation. And so it basically allows for employees to accrue leave at the rate of 1 hour for every 30 hours worked. And I'll be honest with you, administratively, that can be difficult if you're doing it manually, because it's not per pay period, it's per 30 hours worked. And most organizations work on either, a 32 or a 40-hour work week. So you definitely have to keep track of it specifically as it relates to the 30 hours. The employees are entitled to up to 40 hours of leave each year, and it can either be accrued or front-loaded. And whether or not it's accrued or front-loaded will determine whether or not it needs to carry over into the next year. If you front-load the 40 hours and say, here's all your 40 hours at one time, you do not have to roll over into the next year. If you accrue, then ultimately they may not get all of their hours until later in the year, and you do have some responsibility to carry over. But I would encourage you to look at your policies. I will also say that you are not required to create a separate bucket of sick leave. So you don't have to create something separate for this leave. If you already offer PTO or another type of benefit that will allow someone time off for the purposes of this regulation, which we'll get to on the next slide, if you already allow that, as long as it accrues at the same rate as this requirement says or greater, then you do not have to create a separate bucket. And I know that was a question that a lot of employers had initially. Do I need to go back and make a sick bucket? Because a lot of employers do PTO. And as long as they can accrue it and get access to it at the same rate, and they can use it for the things that are on this slide, then you do not have to create a separate bucket. So it's very similar to FMLA to a certain extent. It's to care for their own physical, their own health condition, the health condition of a family member. But I will say that the definition of family member under this regulation is more expanded than the definition of family member under FMLA. So you definitely want to make sure that you're clear about who is a family member under this regulation, because it is more expanded than FMLA. Oh, I have a little extra thing here to care for, for maternity leave, and then absence for domestic violence, sexual assault, because ultimately it's also the safe and sick leave. So it's to make sure that if you needed to go to court or testify as a witness or anything like that, from a safe leave perspective, it's covered there as well. Any
Kimberly,
questions?
we have a quick question.
Sure.
Can you please confirm that we are not required to pay out sick time upon termination?
You are not required to pay out safe and, you're not required to pay out safe and sick leave at the time of termination. However, there is a reinstatement provision. So if you reinstate a person within a certain period of time, then they get access to that leave and it picks up where they left off. But you are not required to pay it out.
And it said SSL, safe and sick leave specifically. I think you got that. So thank you very much.
Yeah. Okay.
I have a question. You said it's for 15 employees or more. What happens if you vary between the number of employees? So in other words, maybe you drop down below the 15 and then 2 months later you're back up. Do you need to keep track of that time frame?
Well, it applies to every employer. The only difference is it's paid if it's more than 15 and it's unpaid if it's less. The regulation does have, it does state, if you go back and forth, I don't remember it right now, but what I will do is send a link for what, I will send a link to the FAQs, because it does answer that question if you go back and forth, but you have to comply with it one way or the other. It's just whether or not it's paid. So I'll send the FAQs from the state that identify what you do if you go back and forth, because I don't remember at this time. Any other questions about that? Okay, and actually, here's the FAQs. I will put it in the chat. I'll
Yeah,
put it
and
in the
it's a
chat.
great time to mention while you're doing that, we will send out a follow-up email after this with the recording with any references. So this link will be included as well as Kimberly's contact information and anything else that she provides or references as resources. We'll try to get those and get those into your hand within the next, by Monday of next week.
Thank you, and great questions. All right, so we're going to talk about, well, maybe we will. All right, so the Fair Labor Standards Act. The Fair Labor Standards Act is the regulation that governs at the federal level minimum wage, hours worked, and overtime. It also covers a few other things, but for the purpose of this presentation, that's what we're going to talk about. As you can see, the federal minimum wage is $7.25, and it's been that, I think, since 2009. So states have decided that they are going to increase their minimum wage as they see necessary. So Maryland minimum wage, sorry, is $12.50 now. It moved up. It's $12.50 and it's $12.20 if you have fewer than 15 employees. Again, the federal regulation is that overtime is earned if you work more than 40 hours in a work week. That is the same in Maryland. Again, other states do it differently. For example, California is overtime more than 8 hours in a day. So that's something to know if you have remote hourly employees in California. Maryland minimum wage is set to increase incrementally up to 2025, and by 2025, it will get to $15 an hour. And Howard County and Montgomery County have different rates. So it's all, and as we go through these regulations, I didn't say there are postings that you're required to have and post for your employees to see for all of the regulations. So, you know, I typically recommend for our clients to subscribe to some type of poster subscription where they'll send you all of the, you know, state and federal and local based on your location. And that way you'll have all of your postings in one. You don't have to do that. The state of Maryland does have a site where they have all of the posters on a page, but you can click them individually and print them out as PDFs. You can do that as well. But you do have an obligation, even with Fair Labor Standards Act, to post the posters and make sure that they're available and accessible for people to see.
Kimberly, with regards to remote work, so many of us have hybrid models and remote. Am I required to, that's the same question I was asking. I just looked, what do we do about remote workers and that requirement to post? It's in my copying room. Am I now required, should I consider sending something, links or something to my remote employees?
Yes. The answer is yes. You do have an obligation to provide posters to your remote employees for the states that they live in. They do have subscriptions for remote employee posters, which are basically a link and they just click on it. It has all of the posters for federal and the state that they live in and the location. There are some organizations, if you use a payroll system that kind of gives you a quote unquote intranet, so like, you know, like an ADP or a Paychex or something like that, even a Paycor or Paycom, they have a page where you can kind of post things. You could put that there. If you have an intranet, you can just put links there. You don't necessarily have to physically send them something. It's just that it has to be accessible by you to them, right? So you can't just say, well, it was available on the internet somewhere. You do have to make it available so you can let them know, hey, your posters are on this page on the intranet, or you can do one of those remote poster subscriptions and send it to them. I have remote employees. I just use the subscription when I hire someone. I just hired someone in Tennessee, and I just went into my poster subscription, added that person. They sent them the link to their Tennessee and federal posters. But you do have that obligation. You also have that obligation if you have people that don't come into the office. So if you have people who take a truck home and really never come into the office, they get everything either by an iPad or, something like that. You should, at least from a safety, with the safety regulations, if they're in a safety sensitive job, make sure that they have access to posters, even if you give them rolled up posters to just keep in the truck. You want to make sure that people have regular access to their posters. All right, so FLSA and overtime. Important to note, employees cannot waive their right to overtime. Comp time, this is something that people love because we live in an area where a lot of people came from government, but the reality is that comp time is not generally permissible in the private sector, generally meaning really is not. So comp time is not a thing in the private sector. State, local, federal governments can do comp time, but as a private employer, you don't have the option to not pay overtime. You don't have the option to say, well, I'll give you time later for the time that you took off. And overtime must be paid even if it was not approved in advance. I've seen a lot of people have policies that say, well, if it's not approved, it won't be paid. That's not an option. The way that you handle that is you discipline the person, you write them up. You say, you must do this, and if you continue to do it, you'll be terminated. But if they actually work the time, they must get paid for the time. So those are some key things to note about overtime.
Kimberly, really quick, back to our, a few of us are now going, okay, what about all our remote workers? The final question, and I think you answered it, but to confirm, if we use technology, Bamboo HR or something like that, a shared Google Drive, if we post their rights and all of the information that we're required to post, if we post it on that shared drive, is that sufficient?
Yes, but I would go a step further and just have a document that says that they acknowledge that, all of the required postings can be found at this site and they've been made aware of it, and then just have them sign it. I'm a firm believer, because let me tell you something, it's good until it's not good, okay? And so people get really bad memories when things happen, and they're like, oh, I didn't know it was there. I didn't know I could find it there. So I am a firm believer in getting people to sign anything that is an obligation of mine. If you don't, because me having posters up in the office, I don't feel like I need to sign something if you work in the office. But if I give you access some other way, I would get them to sign it, but you can't do that. I would just get them to sign something.
Thank you so much.
All right, so every employee is not required to be paid overtime. However, to be exempt from overtime, there's a specific analysis that must be done, and there's a 3-point test that people need to pass. We're not going to go into all of that today, but they have to be paid a salary, which is the same amount of money regardless of the quantity or quality of work. They have to be paid at the salary level, which means that the threshold for the amount of money that they get paid, I think now, I don't remember the exact number, it's around $35,000 a year. And then they have to pass the duties test. Listen, the salary basis and the salary level, super easy to pass. It's the duties test that becomes the challenge. And it's very clear what the types of duties that they need to perform. And that's really where the analysis needs to happen. I always recommend that people have a third party do the analysis on any positions that they have questions about. And I'll also tell you, just because someone has a certain title doesn't mean that they're exempt. Just because you call them a manager doesn't mean they're exempt. So doing that actual analysis is very important. The U.S. Department of Labor does have a tool that you can use and go into and answer questions, and then they'll give you a, likely or not likely this position is exempt or non-exempt. So you can use that tool as well. And I will send that to Angie. So independent contractor or an employee, this is definitely a question that a lot of organizations have as it relates to whether or not someone should be a W-2 or a 1099. I will start by saying it's not the employee's preference. I can't tell you how many times I've had clients say, well, the person just wanted to be a 1099 because they don't need our benefits and blah, blah, blah. It's not about that. So here are some of the factors to consider. All of these factors don't have to be met in order for someone to be an employee. So it's not, if they don't check off all of these things, it is whether or not there's more likely an employment relationship, okay? So if you give the person instructions when, where, and how to do the work, could be an employment relationship. If you provide training on how you want them to do it, more than likely an employment relationship. How integrated is that person's work with the employer's business? Are they able to hire or fire their own assistant? So if they can bring in their own people, if they can say, well, I'm not going to be the one that's going to do the work someone else is, they could be an independent contractor. If you set the hours, if you tell them, I need you here at these hours and on these days, they could be an employee. Are you requiring that they do the work on your premises or in your systems? They could be an employee. If you pay for their travel expenses exclusive of a reimbursement in a consulting contract, right? But if you're paying for their expenses, if you're paying for their travel, they could be an employee. Tools and equipment, if they are making an investment themselves, so like they're investing in all the tools and systems to do the work, then they might be an independent contractor. And if they have the ability to work for more than one firm at a time doing the same work, they could be an independent contractor. So these are some things to consider. This is not an all-inclusive list. And again, they don't have to check all of these factors. Any questions?
We do have a question. It doesn't look like it's related to exempt, non-exempt, but the question is, can you define what is ageism?
Well, depends on the context, right? And typically when I hear it, it seems as if it would refer to some type of age discrimination. But again, it depends on the context. And because that's not a word that we necessarily use in employment, it would really depend on context, because I would need to know how they were referring to it to determine if it was age discrimination. So that's not an answer. So sorry.
So that individual might follow up with you individually with the particular scenario,
Okay.
if they would like to follow up with that.
Okay. All right.
Thank you.
Yeah, no problem. So OSHA is something that we're familiar with, the OSH Act, Occupational Safety and Health Act. If you're in a safety sensitive job, industry, or you have safety sensitive positions in your organization, you have greater obligations such as reporting, filing reports with OSHA. But for organizations that are not, really your responsibilities under this regulation are to provide a workplace that's free from serious hazards, making sure that you're looking at the work conditions to make sure they're safe, making sure that any tools and equipment are safe, making sure that people know how to report incidences and that they feel comfortable doing so and they have a mechanism to do it. And then any serious injuries are reported to OSHA. So serious injuries being hospitalizations, amputations, things of that nature, you would need to report to OSHA. If it's a fall, a twist, carpal tunnel, that's going to be more of a workers' comp issue and not an OSHA issue. All right, I think we're getting to the end of our regulations. So the Immigration Reform and Control Act, this is the regulation that requires organizations to complete an I-9 for every employee. So the form I-9 does two things. It verifies eligibility for employment by determining that they are authorized to work in the authorized to work in the United States by verifying their identity and their employment authorization. I will tell you that the I-9 document is probably the most cumbersome document there is, and I've never been to a client where they were all correct, because there's just so much nuance with completing the form. The other thing that I would say is making sure you have them for everyone, okay? And if you don't currently have I-9s for everyone, make sure you have them. The other thing is make sure page 2 is completed. It is not acceptable to just copy somebody's ID and staple it to the page. You have to actually fill it in, sign it. Can't just staple and leave page 2 blank. See that a lot. And the third thing that I'll say is that you don't have to keep copies of IDs. I know a lot of organizations do, but it's not a requirement. You're required to fill in the document and actually see and inspect the documents to ensure that they are authentic as much as you can, but you don't have to keep the documents. And the rule of thumb is you either have supporting documentation for everybody or for no one. So if you don't have it for everyone, I would suggest going in and doing an audit, and you can not keep the ones that you do have if you don't have them for everyone. And I-9s are only for the people that are hired, and you cannot do an I-9 on someone until they are hired, okay? All right, so things to think about, employer obligations in general. Make sure that all posters are displayed and available, even to remote employees. Distribute policies to employees. This could be done using a handbook. Complete I-9s for all W-2 employees. Track all time worked for non-exempt employees. Make sure that you're tracking the accrual of and the use of required time off. So safe and sick leave, you have to show how it accrues. You have to show how it was requested and how it was used, and other leaves as well. Make sure you're paying employees for all time work, even if it was not paid in advance, and do not withhold final paychecks for any reason, all right? Some best practices are ensure that managers understand policies and are trained on how to administer them. Review your handbooks frequently and make sure that they are updated as laws change. And then I would recommend, if you do not have an HR person, or if you are an HR person, to subscribe to employment updates. So the Society for Human Resource Management, employment law firms, they send out updates and alerts constantly. You just need to subscribe to them, and they will tell you what's happening, even in the states that you don't live in. So if you have employees in other states, it's great to subscribe to those, because they'll give you updates and you can keep abreast of what's going on in those states. So that's it for me. Actually ended on time, which is awesome. I was worried about going over. So thank you so much. And if you have questions, definitely feel free.
It's a great time for everybody to open up and ask some questions. I've already made my list of things to double check and make sure we're doing correctly. I know everyone else is as well, but would love to take some questions before we say goodbye to Kimberly and her expertise.
I think everybody's bored to sleep at this point.
I don't think so. Let's see, please give us the information who we can subscribe to.
Okay.
Is that in reference to for employment laws for each state?
I can do that.
Okay.
I can make some recommendations on places that you can.
Thank you.
Yeah. Mm-hmm.
Thank you. Great use of my time. Thank you very much. So,
I had a question.
yes, please.
Thanks, Ms. Prescott. That was very informative. When keeping notes on employees in reference to any kind of issue or concern, what is the best way to note that? Do I need to advise them of the note that I'm keeping? Like when you're keeping internal records on an employee's conduct, professionalism, behavior, etc.
Yeah, that's a good question. So anything that you put in the employee's actual file, you should make them aware of, and they should quite honestly sign it. So anything that's in their actual file. However, you can have a manager's desk notes. Manager's desk notes are just notes that you're keeping for yourself, things that are not in their file necessarily. You can have those and you don't have to make them aware of those. So a manager's desk note is perfectly fine, but if it goes in their official personnel file, they should be made aware of it. And my recommendation is that it should be signed by them, acknowledging that it's there, not that they agree with it.
Thank you so much.
Kimberly, it means a lot to me personally. Submitting Road, this has been so amazing and one of the best presentations on this subject matter. And I just need to share that because I know the time you take to do this, you give this of your own free time. And this kind of feedback is so valuable to both of us. So thank you.
Thank you. Thank you very much. I really appreciate that. Thank you.
All right. Well, Beth, Leslie, Donna, I hope we continue to see you guys again. Please, everybody, you're welcome to join us in the email follow-up. We'll have, as I mentioned, this recording. We'll also include a link for your feedback. We want to know what you want to know and need to know. And lastly, we have one more webinar in our series next week on HR, and that wraps up our HR series. And over the summer, we'll be doing 5 webinars that are actually hosted by Google. They're trained team members who will be talking about how to better utilize Google to push your business out. So that'll wrap up the end of the summer. We'll be back on our business topics for the fall. So thank you all. Wishing you a wonderful summer if I don't see you again, but thank you. And Kimberly, thanks again.
No problem.
Means a lot to us.
Thank you.